All right, we're all good. Okay, so if anybody has any questions, you can set it up in the chat. You can give me a reaction, or you can use your audio. Okay, you're gonna bear with me because sharing the screen and managing participants is kind of a challenge, but I will do my best. Okay. In theory, if I share the whole thing, it should be easier. Okay. Can you all see that okay? Okay.
Yes.
Let me just keep it in this frame for a second, just in case there's anybody else who tries to join, because it's a lot harder to exit out of PowerPoint and then go back into the Zoom. Okay, so I just kind of want to try to make this as similar to what would happen in person. So I kind of want to just put it this way. This is a very challenging class, as I'm sure many of you are finding, for two reasons. One is that this class is typically taken as a junior in college, not as a freshman or a sophomore. So one of the reasons why this class is offered for criminal justice majors is so that you get it out of the way and you don't have to take it further along the line. So we've done the best we can over the last, I've taught here for 11 years. So we've done the best we can to try to break it down so that it kind of matches up with some of your other classes. That said, legal reasoning is entirely different than what you do in most of your other classes. So that's mostly what I'm trying to teach you is how do lawyers and judges think, because that's the only way to understand how the processes work. So what I've done this semester, and I've tried this approach in the past, and it usually works pretty well, is just put you in the role of a judge. So you get to be a judge for most of the semester, and then basically I'm showing you positions of other judges, so you start to think of yourself as a judge among judges. This picture here, what you see, this is an actual case. So sometimes I get lucky and I pick a hypothetical that ends up having legs, as they say. And this one has some pretty long legs. And it seems like it's going to be in the court system for a while. So it's a pretty perfect example. What I want to show you is just, this is how you all as a group, right? There's two classes, about 30 students in each class. This is how you all are experiencing this assignment. So, I always find this to be fascinating because it changes every semester. And so that's what's fascinating. It's not consistent. So, I have to think a lot about why that is. I'm going to guess it's based on, how the news reports these stories. So I think the main thing is that, there's two groups. And the way we want to think about this in law is that this would be the majority opinion, and this is the minority opinion. So I'm going to say this a couple times, but neither one of these are right. Neither one of these are the right answer. These are both right. It just depends on which group you're in, right? So if you like being in the majority, then this would be your group. If you like being in the minority, then you're fine over here too. The court system is divided. This is what a federalist court system is. It's divided in such a way that there can be multiple opinions on a single issue depending on what part of the country you're in. And so until that issue gets to the Supreme Court, it's going to be divided. So very few issues ever get to the Supreme Court. So most issues are divided. So, I just want to make sure everybody understands that. There is no right answer in the law. There is a right process, and that's the difference. So now I just want to, if there's no questions or if anybody is okay with that idea. Okay. So what were the answers that you all came up with, and why are some better than the others, I think is the big issue. So more or less, the people who said that the court was correct in dismissing the case, they're following a rule. So they're saying they don't care what the reasons are for good or bad, or if the arguments were solid or weak. What they're saying is that a rule is a rule. And so if the rule was that the judge had to follow purely based on whether evidence was presented, then it should be dismissed. And so I want to just compare that to the group who said the legal process should be changed because there should be more time given to Attorney General James. So what this side is saying is, no, they don't buy that argument, right? They're saying Letitia James had enough time to bring this case forward. Okay, does everybody kind of understand that? These are pretty consistent arguments. I mean, you will hear lawyers making an argument like this. They need more time to gather evidence, and so they think that there should be, that there'll be a bunch of different options that lawyers have. But usually judges don't allow for more time because you have to ask this kind of basic question. I would probably write this down, in your notes. Why'd you bring the case if you weren't ready, right? If you didn't have evidence, why did you start this case, right? And there's good answers for that, but they're political answers. They're not legal answers, right? Attorney General James will say something like, well, because Governor Cuomo was pressuring me to bring this case. Because I think, there's a big election year coming up for mayor of New York City, and so it'd be a good idea to make this one of the big political issues. I mean, those will be the reasons why they want to bring the case early. That won't have anything to do with the law. Okay, so I just want to kind of make that clear, that oftentimes there'll be reasons why lawyers bring cases that have nothing to do with whether they think they're going to win or lose. Okay, the next interesting thing is what I really want to focus on in this class is that not fair or morally wrong. This was the overwhelming majority of answers. And I guess the basic thing, I'm going to say this, I feel bad saying it this way, but I don't know how to say it any other way. In the law, there is no such thing as morals, and it really doesn't matter if it's fair or not. That's not what judges do. Now, I can understand why you think that's the way it is. Number one, that's how judges are presented on TV and in movies. They're the great moral deciders, okay? The second issue is if you open up a textbook, they'll start off by saying, law is society agreed upon norms. Maybe that was true in 1600. Maybe. I doubt it. But there are 3 or 4 historians who have made that claim. You will never find a judge that will say that. Judges will never say that what they're doing is deciding what's moral and what's immoral. So this is where in the class I'd ask, and you could write this in the chat if you want, or you could just say it out loud, or you could write it in your notes. Who are the people who decide morals and not, right? Who decides what's right and wrong in the world of social institutions?
Wouldn't that be the lawmakers, legislation?
Maybe. I think they're probably lying to you, but who do we traditionally think of as being people who determine what's right and wrong, or moral and immoral, or I'll give you even a better one, a sin or not, right? Clergy, right? Religious folks. So again, I'm not surprised, right? Because for 1,500 years in the quote unquote West, right? Going from the Romans up through continental Europe, and by continental Europe, I want to be clear there, right? Continental Europe is France, Spain, Portugal, and who am I forgetting? Germany. And Italy. We are not talking about England. England is not part of Europe. England has never been part of Europe. England has never called itself part of Europe. Europeans don't call England Europe. And that's the main point of this class. The United States inherited their legal system from the English common law system, not the continental European system. So when I hear answers that sound like they're Catholic, it's important to remember that English folks have never been Catholic. When I hear answers that kind of give me an idea that Rene Descartes is the philosopher that you're quoting from. You're talking about the French legal system. You're not talking about the English legal system. And you're certainly not talking about the American legal system, with one huge exception, which is the state of Louisiana. If you go down to New Orleans, you're definitely talking about the French legal system. If you go to Haiti, you're definitely talking about the French legal system. But if you go to Jamaica, you're not talking about the French legal system anymore. So, it's a difference that makes a difference, which is what I'm hoping you'll see in this class. They have a very different idea on what should be valued in the court process. So, morals are, it's not that they're not important, and I think it's exactly like Bart said, is that's what lawmakers tend to use, right, to appeal to making laws. So I'll give you a pretty good example that came up in another class of mine. Somebody asked about the hate crime legislation in Georgia, and they made the observation, which I'm guessing they got from the media, that said the reason why the lawyers, and this person actually said judge, did not apply hate crime legislation is that it would be impossible to prove that the individual had intentionally killed Asian women because he said that he was addicted to sex. The problem is that hate crime legislation does not apply to murder. Let me say that again. Hate crime legislation does not apply to murder for a pretty obvious reason. If I murder someone and then I'm sentenced to life in prison or executed, what more could you do to me? So you have to ask yourself, why would the legislatures pass such a ridiculous law that has no meaning whatsoever in law, in the legal system? What motivates folks to pass a bill that almost never will be applied?
Is that a question? Because I have a feeling, or I would like to point out the lynching that goes on in the South. Is it anywhere related to that?
Yes and no. So it is the South that we're talking about.
Yes.
So you can kind of put the two pieces together, right?
I kind of feel like it's an old pastime that as we came to the new time that we're in now, where lynching is frowned upon, that we came out of Jim Crow, I feel like there's something there with that they don't want to punish perhaps people that did it for the 50 or 60 years that it existed, for the most part, freely.
Good. So notice that hate crime legislation is less likely to be used in places where you have a majority white population. And that's the tradition, that's the custom. White people are not going to punish white people for quote unquote hate. So what's the point of even passing the legislation in these white dominated areas?
For future prevention. Not even.
It's hard to think like this. I mean, you have to think like a real scoundrel. The idea is that if I'm the legislature and I pass a law that says, hate crime is bad, that's how the media is going to report it. The media is not going to talk about how this is actually going to apply in the court system. So as a lawmaker, as a legislator, I just solved the problem without ever having to solve the problem because I know full well that the courts are never going to apply this. And that's a lot of laws. There are a lot of laws that the legislatures know will never be enforced, but they pass them anyways, knowing that they're never going to be enforced. It's like shifting the burden over to somebody else, right? It's like pointing your finger. I don't have anything to do with this. I did what I could do. Does that kind of make sense?
Absolutely.
Yes.
Okay. So this is something that in political science we call venue shopping, right? So if you're the victim of a hate crime, right, and assuming you weren't murdered, right, but let's say you were assaulted, let's say they attempted to lynch you, and you want the prosecutor to bring this charge. The second burden is that the hate crime legislation has, again, nothing to do with the courts unless the police department collects evidence, and they have this whole form that they have to fill out if it's going to satisfy the hate crime. So now you see what's going to happen. Is the police department going to do this?
No.
No, they're going to shift the burden back to the legislature and say, well, this is an unnecessary burden that you're putting on us.
But a side note, if I can ask, hate crimes, I understand, can be reported directly to the FBI based on, doesn't matter where you are.
So now you're
can call
thinking,
them.
now you're thinking like a sociologist, even though you never took the class. This is what we mean by venue shopping. If you're the person, and obviously you're going to be in a group, right? So a group of people are going to think about this and say, okay, this is a pointless task in politics, but what we can do is use this new rule and send it up to the criminal justice folks in the FBI. And we can look for a different venue, right? The local court system is corrupt. This is exactly why the FBI is needed, right? We're going to send this information up to the federal government and try to bypass this state problem. Okay, so this is kind of complicated, so I'll kind of return to this idea with the Amazon hypo. Okay. So really fun, it's really nerdy fun, but Letitia James was really smart when she filed this claim. She put it in state court because Amazon violated the state laws, sure, right? That's like the basic junior level of understanding. But she also knew that she's going to have New York judges by filing the lawsuit in New York. If she files it in federal court, even though the federal court is in New York, that's not a New York person. That's not a New York judge. That's a judge that's been appointed by the president, so they could come from anywhere. So she thinks she's going to get a more sympathetic judicial hearing by having it be in New York. But probably even more strategically is she knows that New Yorkers are going to put more pressure on the New York court system than they would on the federal court system, because the federal court judges really don't care what New Yorkers think. Okay, so there's always one layer of politics going on, and then there's always one layer of sociology going on, and that's outside, right, of the actual legal system, of the legal, courtroom. So that's why this answer is an interesting answer. Amazon is a big company, and they were only in it for money. Well, I'm going to say this really harshly. We live in New York City. This town runs on money. So it's not unusual that corporations try to make a profit at the expense of their employees. Now, it's not moral, but that's something for church folks and mosques and synagogues to worry about. That's not for judges to worry about. It's not fair, but, as most parents will tell their kids, life isn't fair, right? So judges aren't going to weigh into that debate. They're going to let that go through the political process. If you don't like Amazon as a big company, there are ways for the federal government to break that company up. And so they expect you to write your legislature, to call up, to march, to do all the things that people do in protest. But they don't expect judges to handle this issue. One thing that I thought was really interesting is folks thought that the legal process should be changed because we're in a pandemic. Now, I'm going to say it this way because we're going to come back to this idea. There is legal precedent, stare decisis, history in legal cases, of there being exceptions during extraordinary circumstances. So this would be an interesting argument to make if I were the Attorney General. I would probably try one of these arguments. I'd say this should not be handled the ordinary way. This should be an example for what the courts can do during a pandemic. So this is a great answer within this line of reasoning. So not a good answer, not a good answer, not a good answer, pretty good answer. This one would be good to argue if you were saying that the case should not be dismissed. And then had probable cause is just showing me that those students are kind of confused about what probable cause is and kind of confused about the process of establishing probable cause. So I'm going to skip that for now because we'll come back to it in a second. The standard reasons for dismissing the case are that the facts do not meet the definition of harm. I think there's some debate, right? And we'll see what the lawyers make, but they could make a debate that COVID could reach the level of harm. It's a tricky one to play with, but that's what courts are for, right? They'll make their arguments. Now this would be an interesting case. The Fourth Amendment protects Amazon employee health records. I know that's what Amazon's going to argue. It will be interesting to see what the courts decide. The only way that the Fourth Amendment would protect the Amazon employment health records is if somehow there aren't duplicates of those records, right? Which I don't know if, when you get older, you have to worry about these things. But if I go look at my health records online, that means that Kingsborough is not the only person who has my health records. I have them. So you can't share the Fourth Amendment with somebody else. I'm going to say that again. You can't share the Fourth Amendment with somebody else. So it's either your home and you have the right to the Fourth Amendment of your home, but that doesn't mean that you can say, come on into the house and search this other person who lives here. Okay, I know that comes up in TV a lot, but in reality, you can't share the Fourth Amendment with somebody else. So this will be an interesting, issue if Amazon brings it forward. And then at the basic, the best answer was there really weren't enough facts presented in the hypothetical. And I got those facts from the actual complaint that James filed. So it'll be interesting to see what a judge ends up doing, but again, it'll probably take quite a while. I'm going to move to the next slide now, and I'm going to open this up here. So after studying this for 15 years, I know the answer, right? So why do people tend to think the legal system is different than it is? TV and movies. Probably the worst among them are like the Judge Judys, because those aren't judges. And that's not a real trial. It's all acting. It's just like WWF. Sorry if I ruined that for anyone. But, the issues are, they're making everything a lot more simple than they really are in real life, right? And that's the main thing. So we have to start with the stubborn fact of what is your legal knowledge based on versus what is the legal knowledge of a judge or a lawyer, right? And judges are lawyers, and so they both go to law school. And that's where they learn the rules of law. And so unless you went to law school, you're never going to know the rules the same way, right? I know a lot of people watch football and or soccer and argue with the referees. They certainly think they're right, but there's no possible way they could know the rules better than the person who's studying and applying the rules every day. So that's the kind of main thing that we have to think about. So we call this the social construction of legal knowledge, right? How legal knowledge is understood by everyone who's it affects. It's different, right? And so that's a problem for law. That's a problem if you believe in the ideal law. It's a problem if you believe that law is socially agreed upon norms, right? That's impossible. People don't have the same experience and they don't have the same understanding. So where do these lived experiences come from? You all know the answers to this, right? It comes from your culture, it comes from your family, it comes from your religion. Especially if you're not religious, it comes from that. And so we all kind of walk in our own bubble of what we think the law is. The other issue is, news, including the fake kinds, right? Donald Trump could complain about fake news all he wants, but it doesn't make it go away. And so, information that's being spread about the law is obviously making a profound impact on what people think about it, especially with, if I turn on the news every day, you'd think that New York was, basically going to end tomorrow. But if you go outside, it's a totally different story for the most part, right? Every once in a while, there's some traumatizing events, but by and large, people are just trying to get by. So then we want to think about this as popular culture. So the popular culture, or the common sense about law is what? It's fair, it's equally applied, everybody has a chance, everybody's going to get their day in court, I have rights, right? There's all these sayings that are adorable when little 7-year-olds say them, but they're not real when we get older. So if I dive deeper into your responses, these are the things I have to, keep me up at night to try to figure out how to teach in the next few weeks. One is that there's a lack of understanding about the core legal processes. In other words, what's the difference between a civil claim, a common law claim, a criminal claim, right? There must be 30 different courts in New York alone. So obviously I can't teach you everything there is to know about the legal processes, but we can start to focus on what are the major differences. So for example, to get a warrant in a criminal case from a judge, signed by a judge, there's a form, there's a piece of paper that you have to fill out showing the specific thing that you're looking for, the reason why you're looking for it, and then some chain of evidence that leads you to believe that the thing is going to be where you think it is. So I'm going to let you guess out of 100 how many warrants actually get signed.
30?
Less, way less. A handful. By and large, police officers are not great at establishing a chain of evidence. Chain of evidence is the number one thing that people call loopholes, right? Following the Constitution is a loophole. Police officers are not great at establishing a chain of evidence. If you saw the most recent harassment in Virginia, those police officers were clearly not doing what they were trained to do. But police officers aren't great at doing the thing that they're trained to do. Okay, if you take Professor Chapman's policing class, he'll explain to you that they're not very well trained. So you shouldn't really expect them to do what they're trained to do. I mean, if you go to a retail store and you try to buy something and you get some, a lippy or a back-talking customer service representative, you can assume they're not very well trained, right? But then you go ask their manager, how many hours of training did you give them? They might say 2 or 3. You say, well, that's really probably not enough. So, you have to think about it. MTA drivers get paid or trained more than police officers do. So you need to kind of put that in perspective about the legal process, right? Judges know far more about chains of custody than police officers do. So there's a big gap there. Then there's a lack of understanding about what a judge can and cannot do, right? Judges are severely limited. There's not much they can do. Now, that doesn't mean they don't have any power, right? And they certainly have influence, but they can't say that Amazon is immoral, therefore we're going to punish you. That's not what judges are able to do. Judges have to take the facts that have been presented to them and then make a decision based on those facts. So they can't take anything outside of those facts. And those facts have to be written down in a very particular way, and then those judges have to base that on legal rules that have been established by hundreds, if not thousands, of cases. And so they're pretty well constrained. There's really not much that a judge can do on their own. So then we have two big problems that we have to deal with in this class. Just ask yourself and ask people why do they have expectations of superhuman laws? In other words, why do people have expectations that if I pass a law, that will deter people from committing a crime? It's kind of like if you see a sign up at a store that says shoplifting will be prosecuted. That is the perfect place to shoplift because they obviously have a problem getting their things stolen. Their idea was to put the sign up to try to stop the shoplifting. But they're very bad at it, obviously, or they wouldn't need the sign. So when you have an expectation of something being different than how humans behave on your block, there's a problem, right? Laws are not going to change how people behave. Think about it in your family. Somebody does something you don't like, you tell them not to do it. What do they usually do? They do it again, more often and louder, right? So that's, we have to think about what are laws really going to be able to actually accomplish. And then this other one I think is interesting is that like the armchair quarterback, right? Or the person who criticizes musicians but doesn't know how to play an instrument, right? We can't think that we know better than the judge, right? We might not agree with the decision the judge made, but we don't know the facts of the case. We weren't sitting listening to the arguments. We didn't read the 50 cases that the judge read, right? It's not our job, so we're not going to do the job as well. So this doesn't mean we can't question them, right, and criticize them or even wonder how they made the decision, but we should certainly be humble about it. So this is where I think, I really want the class to focus, which is, take a look at this picture for a second. I mean, what do you see?
Lack of diversity.
A lack of diversity. So these are federal court judges, and they're almost all white men.
Exception of maybe two.
Right, and they're still pretty pale, right?
Yeah.
So it's in the benefits, it benefits folks who use racism to justify their own privilege for the mass majority of people to not understand how the legal system works. It benefits them. It helps them keep their power. And so what people believe about lawyers and judges matters tremendously, right? Both on a day-to-day kind of aspect and also on how you're going to change your behavior. How you're going to behave is going to be influenced on what you think about the legal system. On the other hand, the harsh reality is lawyers and judges do not spend any time thinking about you, and they don't operate in the same social circles as you. So they know nothing about 85% of the country, right? They don't know what it's like to live in those areas. They don't know really what it's like to work hard. They get to wear a robe to work. I mean, they're living a completely isolated life. So on the one hand, they have this tremendous influence over our life. On the other hand, they have no idea what it's like to be us. So when we make arguments like Amazon's a big company, that means nothing to them. What that means to them is like, yeah, I want it to be a big company because I'm going to get stock returns. I'm going to get dividends from that big company. So I don't really need to care about the everyday worker. I need to care about how much profit is Amazon making if I'm a judge. Doesn't mean that they're all heartless, but they are getting a lot of money to do that job, right? So they're not really living in the same reality. So the other issue is, again, quoting Dr. Chapman, the policing professor, he likes to say a lot of time, you did a great job answering whatever question you thought the question was, but you didn't answer my question, right? So the question, the hypothetical, and I'm saying this because as you do the future exercises, and especially on the final exam, make sure you're answering the question that I asked you. So it said you had to consider the judicial legal standard, and almost nobody talked about the legal standard. And basically, there had to be some piece of evidence that would have kept the case going. And there really wasn't any evidence that was presented that would keep the case going. There was a lot of like, maybe if this happened, if the expert witness doctor could come in and explain this. There's a lot of ifs, right? But if is not a word that is used in law. And so if there's no evidence presented, your case is not going to go forward. So you have to have all that evidence right at the very beginning. And that's what we mean by prima facie. So I put in here is this legalese or is this English? This is most obviously legalese, right? So I want you to think about that, right? Put that in your notes. Most of law is written in a way that certainly my mother doesn't understand. And everyday folks would never understand, right? You'd look at this sentence and say, first of all, how on earth is this a sentence? I mean, it's 5 lines long. That's pretty common in law. So the other issue is that summary judgment means something in law. A motion means something in law. Motion means something totally different if you go to a science class. But in law, it has its own unique meaning. Okay? There's even a legal dictionary that judges and lawyers use that's exceedingly expensive. So material issues mean something very particular to law. the big thing here is like, so the question is, how can I ever know the answers to what these things mean? It's a lot of reading. It's a way of connecting 3 or 4, sometimes more, cases that will use the language, and then you start to get the definition. However, one student articulated it, told the story beautifully. It's just facts after facts. People still need to make their money during pandemic. If you're scared or don't like how something is being done, then don't work at the time being. Yes, that is the everyday interpretation of this legalese. So this is the legalese way of saying it. This is how most of us would understand it if we were just talking to each other, walking down the street at our normal lives. So there's a big gap in the way people talk, right? But the meaning is the same. There's not enough evidence. Case has to be dismissed. If you can't present evidence that your claim is correct, you're going to have to get on with your life. So that's the social aspect of this. We have the judge's point of view, society's point of view. So then I want you to try to remember what I call the 3 I's. There's 3 dimensions of law, or 3 things that you always have to think about. There's the institution of law, right? The courtrooms, these ridiculous costumes that judges wear, the gavel, the briefcase lawyers take into the room, right? That's the institution of law. So these are the norms, the rules, the habits, the things that we typically see on TV. So according to those rules, according to the institution of law, Attorney James has to provide sufficient material evidence. So she said that Smalls and Palmer both raised concerns about Amazon's response to COVID-19 pandemic to Amazon managers. Where's the proof? What would we want to see there? And this is like, I'm supposed to say this is not legal advice, but it kind of is. If somebody does something to you that's wrong in the workplace, email them. It's not enough to say, I talked to my managers, right? In law, we call that hearsay. Email your managers. Document, what time of the day was it? Who were you working with? Say it again.
A paper chain.
A paper chain, exactly. Right? And that's what seems to be missing in this case. Now, I bet Letitia James has this information. And so there's a big, long process in civil trials called interrogatories. But I think she wants to see what Amazon does first. So I think she's got a nice strategy here. But in the document we had, we don't have any evidence that Smalls and Palmer both raised concerns. Now, one student said it's not really fair that the judge doesn't trust Smalls and Palmer. Yes and no, right? I mean, could Smalls and Palmer be lying?
Possible.
Very possible, right? I mean, we just don't really know. And so, again, this is why you need to email. If you ever have an issue at work or at school, right, email and keep the emails. Now, ideologies. This is mental models or states of mind. This fascinates me. Probably when I was in community college, I thought differently than I did after going to law school. But, it fascinates me now that 44 of you were ready to convict Amazon, and Amazon, right? Not anybody in particular, just the whole corporation, without any evidence. And we weren't even in criminal court, right? We were in civil court, but people were ready to punish them, right? As if we were in criminal court. That makes me think of the witch trials, right? We don't even bother with evidence. We just, let's have a trial and let's send her away. If you want to see a funny version of this, you'll watch the Disney, I think it's like 1950s cartoon of Alice in Wonderland. Just YouTube the trial, right? Because this is mostly what the trial was about. It's just nonsense. So ideology is important, though. Where do we learn to punish people for bad behavior?
At home.
At home. Where else?
School.
Right, school. So it's not that this is wrong. This is a evolved social concept. We want to punish people for... Say it again?
It's just taught.
It's
Pass
tough,
down.
right? So I'm going off script right now, but let's say we didn't have any courts. Before everybody says it'll be anarchy, you know, if people were really angry at Amazon and there are no courts, what would they do?
Take it over.
Yeah, take it over, burn it down, protest, right? Boycott. I mean, there's a bunch of other options other than threatening them with a summons and complaint, right? So it's interesting that courts tend to actually defend or shield a large corporation like Amazon. So our desire to punish them really never happens, right? It doesn't really work out that way. Now, then there's the instrumentality, which is probably the most important part. You know, a lot of the people who stuck with the legal rule of the 23, they said that maybe the lawsuit wasn't the best choice, right? So that means that they understand the rules of democratic government, right? That maybe there should be a better law, right? Or as I said, maybe Congress should break Amazon up. I mean, it's kind of amazing that Facebook, Amazon, Google, and Apple have been allowed to be as big as they are. Personally, I'm old enough to remember the 2008 financial collapse. I'm assuming that without that collapse, those companies would have been broken up by now. I think they're just nervous to break up those companies because they don't know what will happen to the economy. So, you know, federal government officials are not doing their job. They're allowing a monopoly because they're afraid of what it might do, you know, in the hypothetical world. So there are other places that people could put pressure if they wanted to make companies like Amazon follow the rules. So I put this in here as like, you know, just to illustrate the point. In some ways, I kind of tricked you. I threw in the Fourth Amendment issue into there's no Fourth Amendment issue in the actual case. I added that because I wanted to see how students were thinking about the Fourth Amendment to bring it back to criminal justice. So I wanted to kind of, let's get these things down, right? A warrant has to be signed by a judge. There's no such thing as a warrant without a judge signing it. I know that there is fake news about warrants that are not signed by a judge. I know that there are some really interesting politicians who have come up with ideas about warrants not needing to be signed by a judge. But in a court of law, there's no such thing as a warrant without a judge signing it. To get one, right? So if you're a police officer and you want to get a warrant, you need evidence of probable cause, not reasonable suspicion. So warrants in the Fourth Amendment have nothing to do with reasonable suspicion. I have to think long and hard about why reasonable suspicion is so often the answer that students get. I'm just going to give you to this way. Police officers, as you kind of probably have figured out, don't need anything to come talk to you. They can come talk to you whenever they want. But let's say you challenge them on it, right? So like the individual in Virginia has already started the process of doing. Their defense is going to be that they had reasonable suspicion. Now, according to that charging document I saw, it doesn't look like they had any reasonable suspicion. But they're going to make the case that they had reasonable suspicion. So who is that really protecting? The police officer. And so this comes out of a case called Terry versus Ohio. So basically, if a police officer does the wrong thing, then they're going to say they had reasonable suspicion to do that thing. But that's never going to convince a judge to give them a warrant. So those are two really totally different processes. Right? A reasonable suspicion you could start to think of like the insanity defense. It's a defense that you give. It's not something that you open with. You don't come up and say, I had reasonable suspicion. Right? It's only if somebody's saying that they had no right to search me, then the person's going to say, well, I had reasonable suspicion. And then, of course, we're going to have to go ask a judge and a jury, what on earth is that? What's reasonable suspicion? So what are warrants for, do you think? Why would I ever want to get a warrant if I'm a police officer? It's a total hassle.
To build a case.
That's an interesting way of putting it, because that's 100% correct. So I think of like the show The Wire, right? Anybody seen that?
Actually, no.
I'd be lying to you if I said yes.
Well, okay, so you'll watch it, right? But there's shows like this. I mean, there are some good TV shows that if they're going to build a case, it takes months and months and months or years, right? So the warrant is like the thing that you need to keep that case going, right? Let's say you wanted to do a wiretap, or you wanted to look at, somebody's bank accounts, or you wanted to follow them as they go and, mule in cocaine, right? That's what a warrant is for. So warrants aren't really about people. Warrants are about objects, right? You want a warrant to find cocaine. You want a warrant to find a gun. You want a warrant to find a bank account. It's not, I want a warrant to go follow Jason around all day. Everybody understands?
Yes.
So that's why so you can also imagine, so I should say, who is most likely to get a warrant? Is it going to be your on-the-street police officer?
No.
No, it's going to be a detective, right? So, I put over here the son of Sam because he eluded police officers so much. So it kind of shows you, right? I mean, murder is probably the hardest thing to get a warrant for. Because what's the object? Right? You won't know until you've investigated the crime. So if you suspect somebody that they're going to commit a murder, it'd be exceedingly difficult to get a warrant because you're not even sure what you're looking for. Now, in criminal cases, what equals evidence of a crime is pretty well settled, right? If I went to a judge and I said, I want a warrant, I pretty much know what I have to show a judge, right? There's been enough cases, it's pretty well documented that that's not too hard to get a warrant. But can anybody think of an area that would be difficult to get a warrant in a criminal case?
Missing persons, perhaps?
Yeah, that's a good one. If somebody's going to kidnap somebody, they're probably not going to keep the same car, right, that was spotted at the scene. That would be one. Terrorism, very difficult to get a warrant. And bank accounts. Bank accounts are pretty tough to get warrants for. Now, in a civil case, right, when you're suing somebody or you're getting sued, it's pretty wide open, right? When it goes to, like, if I were to ask a lawyer, can I use a Fourth Amendment defense in a civil case? They're going to say this third answer. It depends. It's not going to be a yes or no answer. It's going to be, it depends. And it's going to depend on a lot of different things. So a lot of the questions I'm going to ask you moving forward are going to be those it depends. And that's what you have to make the argument. You have to interpret. In other words, given the legal understanding that you're gaining in this class, should someone be able to get a warrant? I'll just give you a spoiler alert, right, for immigration records. Should they be able to get your immigration documentation? Or, I mean, you could think of, like, Speaker of the House Boehner today in an interview said, he's glad he changed his mind about Barack Obama, being born in America. But should I have the right to demand your birth certificate and have you prove, right, where you were born? Or isn't that a health record? Shouldn't that be protected by the Fourth Amendment? Again, it's not yes or no. It depends, right? So Donta, maybe you think it should be?
I feel that way. Yeah, I mean that's private.
Yeah, I don't want anybody looking up my medical information. But I guess, I didn't run for president. But I mean, can you imagine Barack Obama, sitting one day and it was like, they want to know what? I mean, and as a constitutional law professor, he had to think about it. Like, should I try to block this request that they're asking? I mean, it's such a ridiculous request. It's hard to say no, right? You're like, what? Okay. But maybe you should say, hell no, right? No, that's none of your business. But Donald Trump is pretty famous. He keeps claiming that his tax returns are private. That's a stretch. I mean, you share your tax information with a lot of people, right? Unless you don't file taxes, and they're obviously private. But so this gets complicated in civil cases. And civil cases are much more common. I bet you all drive, right? So if you hit somebody and they sue you, that's a civil case, right? That's not a criminal case. So you'd think that we'd have a better answer, but we really just don't. So if this case were real, or another way of saying it would be, if I used exactly the same information from the actual case, the things that are similar is that the Amazon lawyers have already brung a motion to dismiss in both federal court and in state court. The federal court did dismiss the case, and now it's in state court. It will take months, maybe years, depending on how much the Amazon lawyers stall, before we'll know the answer to this question. We could always get lucky, you never know, but I doubt it. There's this thing so this is part of the process. So far, what you've learned about the process is there's the initial case, right? When the prosecutor or the attorney general in the civil situation brings a case, that's what we typically call a complaint. Okay, and that doesn't matter if it's in criminal court or in civil court. After the complaint, easy to remember, the other side brings a response. Now, you would think that the game would get easier after that, but it doesn't. It gets much harder because the next phase of the process is called discovery. And this is very different than criminal cases, unless you go to Russia, unless you go to China, unless you go to Italy, unless you go to France, unless you go to basically anywhere else in the world, they have a discovery process in criminal cases. The United States does not have a discovery process in criminal cases. Can anybody guess why?
I would just assume because it wouldn't favor the large corporations.
You're pretty close. I mean, the only difference is that there were no large corporations in 1776, but there were large plantation owners, which is basically the same thing, right? Yeah. Exactly. It's property, property, property. So in this country, the legal system values property more than it values humanity. And so it's hard for me to say this with a straight face, but a discovery process in a criminal case would be embarrassing to the rich. They'd find out all sorts of things, which is what happens in civil cases, right? You find out all sorts of stuff that you probably would never have known about the people. O.J. Simpson is probably one of the best examples of that, right? The criminal case was pretty straightforward. The civil case was an absolute mess. All sorts of stuff came out. So I guess the lesson is try not to get sued in life. So I listed 5 cases in the hypothetical, which was only about 2 pages long, and no one talked about those cases. So in a real courtroom or a real legal system, you would have had to read those cases and argue for and against those cases in your argument. So one student did refer to one of the cases, so I'm going to call that a victory. I'm guessing most of you just skipped over them, right? Because you probably looked at it and said, what on earth is all that nonsense, right? Because it says, if I pull it up, it says, C. Zuckerman versus City of New York, 49 NY2D 57. I mean, again, that's legalese, right? I mean, that's not, they can't even provide a hyperlink for you, right? I mean, this is how difficult the law tries, lawyers and judges make it. Now, do they intentionally do that? Maybe. I mean, it's possible. Google Scholar has tried to make it a little bit easier. But, in the real world, if you go into a judge's chambers, into the back room, you'll see just piles and piles and piles of pieces of paper, and those are the legal cases. So judges read all of the cases. They know them very well. And these are the cases that kind of matter. So that means that 70 of you made your decision outside of the law, right? So you decided the outcome of the case without ever being inside the legal process, right? So the point here, it's a big gap. I'm hoping you see that. It's a big gap between everyday life and what happens in the life of a lawyer or a judge. And that's kind of the main point that I wanted folks to kind of think about, right? That as you learn in this class, I'm not expecting you to become a lawyer. by June. I'm just hoping that you'll start to see this process of how judges make decisions within the rules of law.
I think that's why I made my decision to keep it going, because yes, they had no facts, but then I know still that it was wrong what Amazon was doing. But, you know, like you said, what's wrong doesn't really matter as long as the facts is
Well,
there.
Can I give you just one point of view here?
Sure.
I'm assuming everybody is from New York on this call.
Yes.
Yeah.
So I'm from Seattle, right? And that's where Amazon started. So I'm right there with you. But we knew Amazon was evil back in 1997. And we tried to warn the world that Amazon was evil. And what did people do? They bought all their shit on Amazon. So I mean, I agree with you, but this is not the first time that Jeff Bezos has done dirty shit. I mean, this is pretty consistent, So I want you to think about it this way. Do you think there's a big business in America that treats its employers better than it treats its president of its organization?
No.
No.
Not one.
So
No.
So Jeff Bezos is what? He's got like $1 billion, right? A judge basically makes about $250,000 a year. A pretty modest salary for the upper class. Now they tend to come from money, right? From backgrounds, so they have like land and stuff like that. But what is a judge going to be able to do, not legally, but socially, to somebody like Jeff Bezos or Bill Gates or Donald Trump? Or, I mean, what are they going to be able to do to them?
Oh, it's not much. They have more.
Untouchable.
Bezos has money, and he can buy
That
whatever
money,
he wants.
connections.
Yeah.
So, on the other hand, right, there's been quite a few untouchables that have been touched. They've been brought down. So what do you think makes the difference? How do you think... I think eventually Amazon, as Johnny Cash said, right, sooner or later God will cut you down. So at some point, Jeff Bezos is going down. But
I think it's more of the paper trails and the evidence that will bring them down.
right. So now, I mean, that's a perfect answer. And this is the issue, right? I bet you that those two people just never thought about writing the stuff down, or even better, what should they have done? Record them, right? I mean,
Yeah.
So I mean, Professor Chapman and I love to tell students, in New York, you only need one party consent to record anyone else, and you're that party. You don't have to have permission to record people. Does that make sense?
Yes.
Now, that doesn't guarantee that recording is going to be entered into evidence at a trial. Okay? So I'm going to give you one more piece of information that is going to come up later in the class.
But an email would, right?
Most likely. Email would be easier to admit into evidence than a recording. Can anybody guess why a recording is difficult to enter into evidence?
Because you need both person consents for the recording.
No, you don't. You don't need their consent.
Some would say that you could alter a recording.
Well, yeah.
Right. It's hard to prove that was the actual recording.
Makes sense.
There's ways to verify it, right? So it's not like it's impossible. But an email is much easier to verify. Now, the other issue, though, and I want you to think about this, and this is like, since I went to college, this has happened. So this is not an old thing. This is pretty recent, in the last 30 years. 95% of cases, that's a huge number, right? Do not go to trial. And that's criminal and civil, right? So what's the number one reason why cases don't go to trial in criminal court? It's two words.
Witnesses or evidence?
It has
Evidence.
It has nothing to do with the legal system.
Chain of evidence. Like,
Nothing to do with the police either. Well, slightly to do with the police, but nothing that they're supposed to do. Ready? Plea, bargain.
I was just gonna.
And it's never a bargain. It's only a bargain for the police, right? And basically they play a game based on the idea that the accused doesn't know math. And so they say something like, what would you rather have, 25 years or 12 years? And the person says, well, of course, 12 years, right? It's like, I remember George W. Bush said, what would you rather have, New York blown up or we invade Iraq? It's like, well, aren't there any other choices or no? Like, is that it? So, what about 0 years? I mean, that's, I'm not telling you how to gamble when you go to New Jersey or Vegas, but, there's more than 2 options. And so all they're doing is taking advantage of the person. And that's why lawyers are important. Lawyers come in at that moment and say, no. 0 is a rational alternative, right? Can you prove your case? Because if you can't prove the case, 0 is a very likely outcome. Everybody gets that?
Yes.
I mean, lots of people in custody take plea bargains, start talking, start doing all the things they're not supposed to do. And then at that point, there's nothing a lawyer can do.
That's lack of knowledge.
Lack of knowledge, right? Same thing in civil court. People will, in civil court, the plea bargain is called a settlement. And I'll be very surprised if this case doesn't settle. Amazon would probably much rather just pay than to have to go to trial. So if you have the money, you just settle. Now there's one other, I'm going to give you the back end of this. One lawyer I talked to years and years ago, he works for a huge firm. They represent lots of big corporations. And I said, how is it that you've never settled? I mean, you're sued all over the place, and yet you never settle, right? And you never go to trial. Any guesses?
Power plays on the smaller guy.
Power plays on the smaller guy. So let me give you one example of a power play, okay? In the discovery office, let's just use this case again. Attorney James is going to ask for all of the emails that relate to this case. Okay? Now let's assume that it's like a reasonable number, like 20 emails. Let's say there's 20 emails. Let's say that the employees sent the emails. What do you think Amazon lawyers are going to do?
Start to shake.
Nope. Let's say you're the lawyer, okay? And I'm the lawyer for Amazon. You work for Attorney General James. Okay? You're going to go to your window. You're going to look out the window. Not really, right? But you're going to go to the window. You're going to look out the window. And outside, there's going to be 2 semi-trucks. Somebody's going to knock on your door. They're going to say, sir, Mr. Fraser, please come out here and help us unload these boxes. And you're naturally going to say, what are these? These are all of the emails. That's what you asked for, right? You asked for all of the emails. So you're going to have something like 3,000 boxes of emails, and somewhere in those boxes are the emails you're looking for. Is there any rule against doing that? Nope.
No, not at all.
There he gets it. So that's one example. The other one is, let's say Letitia James gets a expert witness, PhD from John Jay. And that person's going to say that, they've studied viruses and that, COVID presents a legitimate harm, and so it meets the definition. Amazon's going to get 10 doctors from MIT, from London, from India, right? They're going to get from all over the world, and each one of them is going to walk into that courtroom and say, possibly dangerous, but we don't have enough evidence to prove that it meets the definition of harm. Okay, another power play, right? Expert witnesses cost like anywhere from $10,000 to $50,000, right? So Amazon's got the money, so they'll just buy a bunch of witnesses. Everybody understands?
Yes.
Okay, this is why they say you'll get the best defense money can buy, right? And if you're curious, this is how Kim Kardashian got her money. Her dad was a lawyer.
Yeah.
So there's a lot of money in playing that game. Okay, so does everybody kind of see like the difference between what we'd like law to be and then how law is?
Yes.
Yes.
Disappointing.
It is and it isn't. Go back to the 90s, early 90s, and watch clips of the Detroit Pistons. And the rules are the rules of basketball, right? But there's lots of gray areas in the rules. And if I elbow you and the referee doesn't see it, then it's not a foul, right? So I didn't really break the rules. And that's how lawyering works too, right? If you can't prove that I broke the rules, then I didn't break the rules. Everybody kind of gets it?
Yes.
Okay.
Yes.
Can I give you a preview of the next office hours?
Yes.
Yes.